Good evening, ladies and gentlemen. This is the November 8, 2018 meeting of the Municipality of Anchorage Board of Adjustment. I'm Vern Kucher, its chair, and I'm glad to see people in attendance, other than just the board members. So thank you for coming. The first order of business here is the roll call. Madam Clerk, would you please call the roll?
Chair Bert Kuchak.
Here.
Thomas Deek.
Here.
Bob Stewart.
Here.
Chair, you have a quorum.
Thank you. I should also mention that we have, in addition to that, the clerk in the back.
Staff
Who
support,
is-
Amy Solberg.
Thank you, Amy. And we have our trustee lawyer, Courtney Kitchen, to my left here, who are also present. Would you please take a look at the agenda for tonight and see if there are any additions, deletions, changes that you wish to make? Mr. Stewart?
No changes.
I have no changes either. Seeing no changes, the agenda is approved. The next order of business is to consider the minutes of the previous meeting that occurred in some time ago, actually. And we are talking about 2017? No.
No. 29 on the 18th.
Correct.
Did I miss that?
So we are looking at the May 9, 2018 minutes, and I will give you a minute or two to review those and see if there's anything that requires changes.
Would you like to speak to that?
And I think, Mr. Dieck, you were talking about a change that needs to be made on page 3.
Yes, there was one on discussion guidelines for form of notices under item C. There's a statement on second paragraph which talks about the appellant brief which needed to be corrected. And it would be a little bit clearer if we modify this paragraph by second sentence after the date by deleting the exhibits not in the record, adding not in the record, and referencing pages in the field record only.
Okay,
Other than that, I think it's accurate.
all right. Mr. Stewart, anything that you wish to add?
No, I think that helps define what that order actually was.
Okay. Any other changes, deletions, modifications that we need to make? Seeing none, any objection to approving the minutes? No objections, the
Objection.
minutes are approved. Next item, old business, there is none. And that then brings us very quickly to the main item tonight concerning BOA Appeal Number 2018-1, Planning Board Findings of Fact and Decisions for Case Number S12388, Lewis and Clark Subdivision Lots 1 through 16 and Tract A. We are here today to consider this appeal, and before we do that, we need to, as always, ask about conflicts. Are there any conflicts that need to be brought to the attention of this meeting? Mr. Dieck?
Not on my part.
Okay, Mr. Stewart?
I have no conflicts.
And I should state for the record that I do not have any conflicts either. All right then. We need to, there's one additional item that I need to address, and that is, Mr. Dieck, your term has expired. Officially.
Don't pick on me. I think it's several of us. Isn't it like 2 of us or 3 of us?
Well, I think I just
You
got
did, you did.
reaffirmed, so
You did.
I got confirmed.
I did too.
I think.
And you did too, so I think it is just you.
That's me.
Anyway, what saves you this time, and what saves the panel in the consideration of this case is that there's a 120-day savings provision there in AMC 405040, and that says that you have another 120 days after your appointment expires so that you can still sit on this, because it would be a problem if you couldn't.
Quite
Frankly. So we should just state for those people in attendance here that Mr. Deak is serving kind of, what would you call it, kind of a grace period here?
I think actually, since the reappointments are in October, it's called the 120-day extension
Yes.
for action, and we are in the first month of that, so we are safe.
We've got plenty of time, but hopefully we will get through this case tonight. All right then, let us get right into the case. The first item that we need to consider is there is an issue regarding exhibits that were attached to briefs, and as we all know, we are governed by the provisions that state that we can only consider items on the record, in the record on appeal. And so the first item is to deal with exhibits in various briefs that are not part of the record on appeal. And the way that I would like to do this is that we need to put a motion on the floor, a positive motion, and then we can discuss that, okay? If neither one of you is prepared, because this may come as a kind of a surprise,
Sure.
I will
Yes,
be
it
happy
is.
to do it myself, unless Mr. Dieck, do you want to take a stab at it?
Absolutely, Mr. Chair, I would like to move to have a discussion on the appeal record in regards of exhibits which were not part of the original record.
Okay, I would like to turn that into a positive motion that exhibits 4, 18 through 22A, 25, 27 through 29, 31, and 34 of appellant's notice of appeal, exhibits 1 and 2 in appellant's brief, and exhibits A, B, and C in appellant's apply brief be disregarded. And that's really what you wanted to say, wasn't it?
I wanted to say it faster, but sure.
Okay. Mrs. Stewart, are you going to second that motion?
I will second that motion for discussion.
All right, then let us talk about it. Mr. Dieck, are you prepared to talk about, to address the motion?
Well, I'm gonna start with it, and then I would like you to fill in. But basically, the original meeting on May 9th already has discovered that the appellant's motion had included exhibits which were not part of the original record, and therefore you released a request for a new brief, which was requesting the briefs to omit those. They are still part of the appellant's brief, and since we are bound by regulations to not consider anything which is not in the record, that's why we have this motion, and that's why I would support it.
Okay, Mr. Stewart.
I think that you've effectively identified all those exhibits that were not part of the original record that was before the planning board. And I think from that standpoint, I believe the motion is appropriate, and I intend to support it.
Okay. I intend to support myself. It is clear from what we have in terms of the briefing that the appellant's brief and the appellant's reply brief contain exhibits that are not part of the record. And pursuant to 2103-050A11A, we can only consider those items that are in the official record of appeal. So, any further discussion regarding the motion? If not, are we ready to vote?
Yes.
Okay, Madam Clerk?
Mary Kuchar,
Yes?
Tomasky,
Yes.
Bob Stewart,
Yes.
The motion passes 3 to 0, I'm so sorry. And the exhibits that are excluded from consideration and were excluded from consideration are exhibits 4, 18 through 22A, 25, 27 through 29, 31 and 34 of appellant's notice of appeal, exhibits 1 and 2 to appellant's brief, and exhibits A, B, and C to appellant's reply brief. Now, there's one additional item that we need to consider, and that is a reference in the appellee's brief to the Hillside District Plan. Now, the Hillside District Plan is not part of the record on appeal, actually we would have to exclude it, but there is a theory of law that is widely accepted, well accepted, that that we can take judicial notice of legal action that has been taken, for example, legal action by the municipality. And so I am going to entertain a motion that the Hillside District Plan, having been adopted by the Municipal Assembly on April 13, 2010, is part of the legal framework of Anchorage, and thus the Board of Adjustment takes judicial notice of it as contained in an attachment to appellee's brief, even though it's not specifically referred to in the record on appeal. And Mr. Dieck, you are seconding that motion?
Oh, if it was a motion, I was going to make one, either way.
It's okay, I made the motion and you seconded it, I
Yes.
gather. All right, let me just briefly talk about it. The Hillside District Plan is part of the official legal framework of the municipality of Anchorage, and just as this board and other boards can take judicial notice of action of laws that exist, so we can take judicial notice of the Hillside District Plan that was approved by the Municipal Assembly on April 13, 2010. And in order not to shortchange the parties, and we could easily simply say it will be disallowed, but I think it makes more sense in this case because it is part of the appellee's brief, and we can easily make it part of the record because it is part of the legal framework of this community, and therefore I support the motion to take judicial notice of this matter. Anything you wish to add? Anything, either one of you? Mr. Dieck?
Yeah, I do have one comment, and maybe just to strengthen the motion, is that the Title 21 actually does specifically list the Hillside District Plan under Table 2101-1, which is the comprehensive plan elements. And since we are using Title 21 as our legal framework to do these proceedings, it's part of the proceedings.
Okay.
So I think it's a strong defense for
Yes.
supporting this motion.
Thank you for that explanation. I do appreciate it. Mr. Stewart, any comment?
I just have a question. That reference that you referred to, does that refer to plats and things that the city has taken action on in relation to this case or other cases? Would that occur? Would that be a plot?
I do not believe so. It was simply,
Or
the Hillside District Plan was simply referred to and attached to the appellee's brief.
that would be part of the law itself.
Yes.
That we
Yes.
recognize. Okay.
Right. So I do not, off the top of my head, recall any discussion regarding the Hillside District Plan by the appellee, but anyway, there it is. Okay, anything further before we vote on this matter?
Can I make
Yes.
a comment about Mr. Mr. Stewart's?
Yes.
About the plots. I think that maybe what you're referring to is there is some older applications that were part of the exhibits that are not part of the appeal record. Is that what you're referring to?
Well, that's a possibility.
And that would be something that you could take notice that it was submitted, but you can't use the facts that are alleged in the application itself.
Okay. All right. Thank you.
Does
that clarify?
That helps.
Okay. Any further comment regarding this motion? If not, Madam Clerk, would you call the roll, please?
Verda
Yes.
Tomasky,
Yes.
Bob Stewart,
Yes.
And the motion passes 3-0. And you need to give me a second here to simply make some notes here for myself. All right, we then come to the substantive portion of the appeal, and that's of course why people are sitting here. The procedural niceties are interesting to some of us, but maybe not to others. Anyway, we have, and our council has identified 7 substantive issues that we need to address. And I suggest that we simply go through each issue and start by putting the matter on the table via a positive motion that will be seconded by someone, and then we discuss the motion, and then we will vote on the matter. And depending on the outcome of the vote, that will either terminate the appeal before the administrative board, or it will require further action that we will need to decide on if the motion fails. Okay? So the very first issue, substantive issue that we have, concerns the Canyon Road variance. And I would ask for a positive motion along the following lines: that substantial evidence supports the Planning Board's decision to approve the Canyon Road pedestrian access right-of-way easement variance under the criteria of AMC 2103-240G3.
So moved.
Thank you. Mr. Dieck, are you going to second that?
Yes, I will.
Well, thank you. All right. Mr. Stewart.
The first thing that I think we need to consider here is AMC 2103-240 G3 A through D, and that was addressed by staff on the record at 231, page 231 through 234. But there's 4 criteria, and as I read through the 4 standards, what I also looked at was AMC 21.11.304 decision.
Could you give me that citation again? I'm sorry.
Alaska Administrative, AMC R 21.11.304, which is the decision. And this is referring to the regulations that govern how the Planning Board operates. And it says, findings shall, which is mandatory, be sufficient to provide reasonable basis for understanding the reasons for the decision. And in A, this is part of A, in considering and applying any applicable approval criteria, the plating, it says it forward, but I'm substituting plating in there for it. And this is again mandatory. Shall make specific findings as to why the criteria have or have not been met. Now, to me, that means there must be a finding as to why or why A or B or C or D actually applies or does not apply. And I don't think that decision, I don't see that decision in the record, and I don't see it in the findings, and I don't see that it was actually addressed other than from a safety issue. And it seems to me like the safety issue itself was used as an overriding, what would you say, criteria that overrode the rest of the criteria. But it looks to me like there needs to be an assessment of whether each one of those individual criteria have or have not been met.
So is it basically your position that the decision is deficient in failing to address specifically the 4 criteria? Is that what you're saying?
I think that it is, and it's a matter that should be addressed by the planning board.
Okay. So what is your position on the motion? Or do you wish to withhold that and listen to further discussion of this?
Well, let's keep the discussion going on this, because this obviously is something that this is my interpretation of the regulation,
Okay.
and it seems to it's mandatory because it uses the word shall in 2 places. So I think that in itself is a pretty strong admonition to the planning board. But I'd like to hear what the rest of you have to say.
Okay. Mr. Diak?
Yes, page 191 of 496, which is the findings of fact and decision for this case. If you look at the findings, item number 3 is the finding which is specific to this particular item, which is the internal street connectivity in the code, which you already referenced. And the finding states several items here, and my concern with those is that not that they don't necessarily address A through D of the 4 standards, but there are factual, some of them are factually incorrect based on the record. So, so one of those ones is the last, the third from the last sentence of that section, which is again findings number 3, and it reads: the pedestrian route by road is only 200 feet longer and it would achieve the same objective as a trail. This particular statement was made in the record for the other variance, which was for the other cul-de-sac. So just in itself, it's just the wrong application of facts. There is other items here which are listing the fact of staff not supporting the variance, because the staff meaning the planning staff not supporting the variance based on their analysis. And that analysis actually contained the length of the additional length which you have to go on an alternative route. I can find a page for that, but I think it was like 2,200 feet or something along those lines. And I know this is a little bit more, I'm going to give it to you in a minute. It's under page 233 of 496. This is item C. Staff analyzed it by variance 1, 2, and 3. So this is variance 3. And it lists that the trail connection is approximately 2,200 feet shorter than walking the long way around. So I'm concerned about that being a factually not correct statement in the findings of the record. And also, there is no analysis in the findings of the individual criteria being met, meaning A, B, and C, and D separately stating why or why not the variance is meeting the threshold. And I think that I would join to state that that is not something that the record tells us to be able to analyze.
Mr. Dieck, you have been on the planning board.
I have been, yes.
Is it customary in planning board decisions where variances are considered to specifically address the four considerations of 2103 to 40G, A through D? You know, those four considerations.
I think I'd probably be, just because I was on the planning board, I'm probably not the authority on telling you what's customary and what's not. I do know that the staff analysis always goes by A through D. And if you look at the record on that, that is pretty clear on how they looked at the variance analysis, as I stated here on page 231 is where the variance request analysis starts, and going through items A, B, C, and D through pages 234, which is customary of their process. Therefore, it is customary of at least the board to look at the topics individually. Generally, and I can't speak for any other boards, I've said on some, it is the standard that you go through each of them and try to find the findings to support or not support the variance request.
Okay. Looking at the decision then, do you find that although it does not address A through D specifically, that there's enough there to say that it was implicitly discussed, addressed?
Put me on the spot here, but I think what I would say that based on this record, to me, a variance is a fairly high threshold.
Yes.
And based on what I see in the record, this finding simply doesn't support granting the variance. To me, that's what it means.
Okay. And in terms of the decision, let us look at the decision statement, which is on pages 185, 86, and 87, and specifically on the bottom of 185 and the top of 186.
Okay, shouldn't we be looking at 191?
Well, I am looking
It's
at
the same thing.
findings.
Right?
I am looking at findings. It's the same thing.
Yeah.
It's exactly the same thing.
Yeah, the formal record starts at page,
It's identical.
yeah, it's the same thing.
Yeah.
Yeah.
Yeah. So my point is, do you then find that this is insufficient to justify, the finding is insufficient to justify the granting of the variance? Is
I
that
would.
what you're saying?
Yes,
Okay, so you would vote against the motion?
I would.
Okay, all right. Okay then. I know that Mr. Stewart has not said yet how he wants to vote on this. I can tell you that I find that of the four considerations, A is satisfied. When we look at the transcript on pages 56 and 57, we find a significant discussion there by Mr. Cross and also by Mr. Seward, I'm sorry. And I conclude as a result that small a of 240G is satisfied. I also conclude, for the same reason, that consideration B, variance will not be detrimental to public welfare or injurious to other property, that is satisfied on the same basis. Similarly with consideration C, and that is the variance will not have the effect of nullifying the intent and purpose of the subdivision regulations. A reasonable alternative exists as described on pages in the transcript, pages 56 and 57, the statements by Messrs. Cross and Seward. And so for that reason, I would find that that consideration is satisfied. The issue, of course, to me at least, is small d. And that speaks to strict compliance would cause undue hardship. And I do not find that the hardship consideration was really addressed. Now, we can point, and as our counsel has pointed out in her memo on pages 9 and 10, that we can consider the testimony of two individuals who testified. One of them is the petitioner, and the other one is so Mr. Gionnet, I think that's how you pronounce his name, is the applicant, and he testified to the fourth consideration. And similarly, Mr. Pugh testified that the Rabbit Creek Community Council did not support the required pathway due to safety concerns. So I think we can say that the considerations were met of 240G. They were simply not articulated in the decision sufficiently that I have a firm feeling that the board really considered all four considerations of that subsection. And so, in my view, the decision by the planning board is deficient in not addressing the four considerations specifically. And it is for that reason that I would vote against the motion. Okay? And that now leaves Mr. Stewart.
I've got some problems with the Mr. Pugh's testimony and what he talked about during the hearing, because the Rabbit Creek Council voted to withdraw that comment regarding Canyon Road support or non-support.
Okay.
So in my view, what he did is that should be characterized not as a word that says they do not support. They became neutral, just like Hillside Community Council. So I don't read that as support, but I look at what Mr. Cross was saying, and it looks like he was interpreting what Mr. Pugh was saying as not his personal opinion. But I think what he was doing was asking for the personal opinion of Mr. Pugh, and not the opinion of the Rabbit Creek Community Council.
Mm-hmm.
So I don't think that you can say that the Rabbit Creek Community Council did not support, because there's no affirmative. I think it was neutral when they pulled that item from their letter.
Okay. So where does that leave you?
And there's one other thing that I wanted to address, and that is Canyon Road, because the mention was made that this would be very dangerous for people to come onto Canyon Road during the construction. Well, Canyon Road construction is a temporary thing. The variance is a permanent thing that goes with the plat. So to me, referring to Canyon Road construction as exacerbating the danger of someone coming onto Canyon Road shouldn't be given the weight that it was given in that hearing, because Canyon Road apparently is going to be worked on in the near future. But the other thing is, if you'll look at on the plat itself, you'll see that the section of Upper DeArmond is right along the edge. And as I look at that, I'm sure that there's hardly anywhere for anybody to walk right along that one section of Upper DeArmond just before it gets to that intersection of Canyon Road and, what is it, it's something View Way or something,
Okay.
right up on the corner.
Yes.
So, from what I can see in the record, both of those really have some real issues of safety of people walking up and down those things, especially at night.
So would that lead you to support the variance or oppose it?
No, I would oppose the variance, because I think there's a reasonable likelihood that the dangers that are associated with walking along Upper DeArmond Road and Canyon Road, even after it's completed, are still there. And it's better to have the people in the development have access onto Canyon Road. It's further down. It's not up close to the intersection. But I think that would give a better way for the people to get out and walk and maintain that community egress-ingress from a cul-de-sac, rather than going up and walking down along both of those roads.
So you're saying that the variance should not have been granted?
Yes.
On the basis of the evidence that we have before us?
That I can see in the record, yes.
All right. Any further discussion regarding the motion then? Remember, this was a positive motion that stated in essence that substantial evidence supports the planning board's decision to approve the variance. Okay. So you would vote against that motion, I take it?
Yes.
Yes.
Mr. Dieck?
I would vote
Any
against
further
it.
discussion regarding the matter?
The one question of process.
That we will discuss.
F.
That will be, perhaps, that will be the next portion of the consideration of this issue, yes.
Okay, then I will just state that I will vote against the motion.
Okay. I have stated before that I do not support the motion, and I think we are ready for a vote. Madam Clerk?
Verguccio,
Nope.
Tomasky,
No?
Bob Stewart,
No.
All right, the vote is 0-3 in favor of the motion. It means the motion has been defeated. And the question, of course, now is, where do we go from here? As our counsel pointed out, we have various alternatives. We can, let me just very quickly go to this. Courtney, where did you discuss this?
I think it's on page 9.
think it's on
Page 9, yes. So, the alternatives that we have are we can either hold that there is, the findings are supported by substantial evidence and affirm the variance approval, and we have voted against that. So the next alternative is that we substitute our independent judgment by unanimous vote and reverse the variance approval, citing to substantial evidence supporting the BOA's reversal. Or 3, if the record has insufficient evidence to determine this issue, remand the matter back to the planning board with direction to take further evidence about whether the criteria of AMC 2103-240G are met or not. Okay? So we really have 2 alternatives. We can either substitute our own independent judgment and do what we feel unanimously is correct, or alternatively we send the matter back to the planning board. I have been on this board for a long time, and I tend to give considerable deference to the decisions of boards that we review. And so I must tell you that my druthers would be that the planning board needs to reconsider this. Having said that, the first time around that they heard this matter was almost a year ago, 10 months ago. And if we were to send this back, we would then, it would probably not be considered, 2 months? Probably 2 or 3 months, perhaps,
Yeah.
down the road. Whether that would delay the project at all, I can't tell, but it does not provide a closure for either party. You know, that's the disadvantage of simply sending it back. On the other hand, as I said, substituting our own judgment for that of a 9-member board is a tall order. And I would suggest that that should only be reserved for the most serious of cases. So I think, in terms of thinking about this and articulating what we want to do at this point, is that I think we need to first make a motion and then discuss this a little further. Okay. So I would invite a motion first to remand the matter to the planning board for further consideration of the 4 criteria that are applicable to variance requests. And if you're thinking about this, or if you're not willing to make that motion, Mr. Stewart, perhaps you are.
Okay. I make a motion to remand the matter to the planning board with direction to take further evidence about whether the 4 criteria of AMC 2103-240 have been met. And okay, I meant to say applicable for the variance to be met.
Try this again. Would you
Okay.
rephrase your motion? You move to remand to the planning board.
Motion to remand to the planning board with direction to take further evidence on whether the 4 criteria of AMC 2103-240
Have been met. Have been met.
Okay, that works.
Does it work? Okay.
That works.
Okay, Mr. Dieck, are you going to second that?
Yes.
Okay. Mr. Stewart, would you speak to the motion, please?
I agree with your assumption that the planning board has the ability and the capability to look into this and make a decision. And from my standpoint, I don't think that we should try to override something and make a judgment decision when you've got a board that is able and willing to do that with direction.
Okay. Mr. Dieck?
You're correct. I've been thinking, and I've been thinking about the process for two reasons. One is that you're correct about stating that the development processes are taking a considerable amount of time to go through the municipal review of various types, in this case planning board, just to prepare the applications, get the staff reviews, get the noticing. This is going to be obviously a variance, so it would be a variance, so it's going to be a hearing, what it's called for a long plan. Takes months really to get through. This process has been going on with the same conditions for the same variance, and the flooding board took an action based on what we saw. And in my view, the big question is there enough evidence in the record as is today to make substantial judgments on it and make a decision? And I'm leaning actually to say that I think there is. And what I would say supports that is that there was a substantial discussion on this issue, and there was not a singular issue on this project, because there was another variance exactly the same type, except for the physical characteristics being different. And the board actually did do the analysis, did do the action, did go through the motions, did do the approvals, and did find the findings without appeal. I think on this particular issue, there's a bigger question whether the variance conditions are met. We have just discussed that, and we have voted that the findings were insufficient. But in my view, the findings may point to the other direction, and that's where my hesitance of which way I would want to go with the remand versus not, because I think there is a substantial data set in this project to make that decision. So I'm thinking.
So you're thinking, okay. While you're thinking, let me suggest that I'm leaning in the direction of sending it back for specific consideration of the 4 criteria of the ordinance involved here. And we are talking, of course, about 240G 4A through D.
Right.
And I must tell you that what I'm unhappy about is when I look at the decision of the planning board is that they do not specifically address the 4 criteria. And so, to my way of thinking, whether there is enough in the record or not, that is not determinative for me. What is determinative for me is that there is a failure to discuss those specific 4 criteria. It is not addressed in the order, and it should be addressed in the order. And so I would send it back for specific discussion, further evidence to consider whether the 4 considerations have been met. Mr. Stewart stated that he wants to have further evidence taken. I'm not going that far. I want the board to state on the record what they based their decision on. And it may very well be that, as Mr. Dieck states, that there's enough in the record to actually approve the variance. It is just that they haven't addressed it properly, to my way of thinking. whether that requires the taking of additional evidence, I'm not so sure about. And Mr. Stewart, I'm not sure whether you really meant that there is another public hearing on this matter, or whether you simply meant that the board should reconsider this and state specifically, by stating the four considerations, A through D, what
Okay.
they based their decision on.
If they can do that and articulate why each of those four criteria
Has
in
been met.
3, I think you may have said 4, but it's
There are four,
Yeah.
A through D.
yeah, in paragraph 3. If they can articulate that, then I think we have resolved our issue with this.
Okay.
I don't think they need to have another public hearing, but they need to be able to articulate whether each one of those four criteria either have been met or not have been met, and specify in detail why each has or has not been met.
Okay. Mr. Diak, does that meet your thoughts on this?
There is one thing I'm considering and thinking about is that remanding it back requires that you have the process to be thorough enough to vet the project.
Yes.
So when there is conclusions made and decisions made and findings are made, we don't go through the same loop of appeals. And I'm concerned about that. And the reason I'm concerned about it is because, as I said, the record as it is, to me, doesn't speak to strong support for this variance. And
It does or it does not?
does
I'm sorry.
not. Does not.
Okay.
And because of that, remanding it without seeking information for each of those items to be strengthening the case for the findings, if it is in favor of approval, I think that would allow both the petitioners and the public to vet it at a basis which then has the chance to stick at the lower board and not come back up here.
Okay. So you would say that further evidence should be taken.
I do think that would be appropriate because that allows the process to go and extend it so the petitioner can strengthen the case to support their case and have proper evidence to back it up.
Okay. Mr. Stewart, does that make sense to you?
Well, can you have a remand and the plating board consider a remand without being in a public hearing?
No, I don't believe so. Every meeting has to be a
Yeah.
public meeting.
So it's going to be a public hearing.
But the question is, of course, whether the proceedings will be open to testimony or additional or submission of additional material, pro or con. You see, and what Mr. Diak is saying, yes, it should be reopened to give the applicant the opportunity to strengthen his case, and
But if you
the
give it,
opposition perhaps to come forward with more evidence as well.
but to be fair, if the applicant is given the opportunity to add more, then the appellees and the appellants both
Yes.
should be given the opportunity.
Oh,
Yes,
absolutely,
absolutely, yeah.
absolutely. That's
To be
why
fair.
that further evidence should be taken. You know, your motion was, as I understand it, motion to remand to the planning board with direction to to take evidence and specifically
About whether the four criteria.
whether the four criteria have been met, number
Have been
one,
met.
and to state in their decision that each one of the four criteria either has or has not been met.
Right.
Okay? Does that make sense?
Yeah, exactly. That's to me.
Okay. Yeah, I can support that motion. The question is how to word this narrowly. And Ms. Kitchen, it will be up to you in the decision that you're going to draft for our consideration to state this so that it's specifically narrow, yet expresses what we want, which is it should be remanded with direction to take further evidence in favor or against the variance request, and to state in its decision specifically whether the four criteria contained in 2103 to 40 G3, I think it's G3,
Yes.
It is G3.
okay, have been met or not. Okay?
Yep.
Do we understand the motion? It's a motion to remand. All right. Is there any further discussion? Seeing none, Madam Clerk, would you call the roll?
Mayor Guccio,
Yes.
Tomasky,
Yes.
Bob Stewart,
Yes.
All right, the motion passes 3-0 to send the matter back to the planning board with direction to take further evidence in favor of or in opposition to the variance request, and two, in making the decision regarding the variance request, to address the four considerations contained in 2103 to 40 G3. Okay? All right. We have disposed of the very first issue. Isn't that nice? So, the second issue contains the plat note regarding the maximum lot coverage. And this matter is addressed by our esteemed lawyer on pages starting 11 and going on through page 13 and a little bit on page 14 of the memorandum, of the confidential memorandum that we have here. So in order to raise this issue properly, I will entertain a motion that the planning board did not commit a procedural error by failing to require a plat note detailing the maximum lot coverage allowed under 2108-070B5. May I have
Mr.
that
Chair?
motion, please?
Yes, Mr. Chair.
Thank you,
I would
Mr.
like to
Diak.
make that motion.
All right, Mr. Stewart?
Just one
Second.
clarification
Oh.
on that you are stating it, the planning board have not committed a procedure.
Correct. Yes.
Thank you.
Mr. Stewart, you are seconding that
Yes.
motion? Okay. Mr. Diak?
Yes, this motion is about the code requirement that the plat notes state the reference which it is applicable for the plat itself. This is a preliminary plat. And the actual reference is 2108-07B5. The discussions on this issue have to do with a conservation subdivision's ability to reduce lot sizes, but because of that process, it allows lot coverage for within those individual lots which are created. And the contention here is that the planning board has committed an error by not specifically stating the actual number of coverage, which is supposed to be in the table, versus just citing the reference, which is referencing the table. And in my analysis of this, I do not believe that the planning board commit any procedural error, because the reference is clearly describing the table and basically the math which is contained in the table to allow the planning board to make the decision the staff to do the work and then the final plat to do the analysis. I do not see any procedural error because by just referencing the applicable code, that the applicable code provides the backing of doing the actual project calculations which are necessary for this coverage discussion. And I think I made a note for myself on lecture coverage. I know it's in 2106, but I'm gonna tell you where it is because I think it's relevant to look at the dimensional standards.
You're looking at 2106-010A.
And I'm probably gonna not say again, 2106-010A.
That's looking at the purpose of the lot coverage.
Just give us
2106. Hold on. And
Now,
what's the
maybe
last?
I'm getting ahead of you.
So I found it. It's 2106-020,
Yes.
which is the table 2106-1, which is the table for the underlying zoning district lot coverage area.
Okay.
And then in that, R8 allows 5% lot coverage, and the code reference, which is in the record, describes the additional allowance for up to 10% of lot coverage. And that is very specific based on looking at the references as the planning board has made the action. I could do it myself based on that code reference. So I don't think that was a procedural error not to include the actual lot coverage.
Okay. And so you plan to vote in favor of the motion?
Oh, I did not say that, but I would plan to do that, yes.
Okay. Mr. Stewart.
Well, it could be, it would be helpful if they, it would have been discussed a little bit more in detail, but I don't see any problem with it. The only problem that I look at is it would be nice that if the planning board would, in the future, if they would look at these things and recognize that there is some approval criteria when you're talking the maximum lot coverage, right?
Yes.
Because when the planning board approves a preliminary plat, they do so only, and this is under 2103-200B9. The planning board may approve a preliminary plat or a final plat only if it finds that the plat conforms to the applicable standards and measurements. And then it refers to Chapter 21 Development and Design Standards and 2108 Subdivision Standards. And then there's some additional things that look like they go into policy. But lot coverage is one of those standards. And when you look at 2106-010A, the purpose of the Chapter 21, one of the things that it talks about in paragraph C is controlling the overall building bulk and lot coverage to help define the character of the different zones. So when you're dealing with lot coverage, that is a key factor in defining the character of a zone. So that should be something that should be looked at in future cases, rather than leave it up to interpretation as to what that particular section means, because it was interpreted differently by the appellants, and it was interpreted differently by the appellees. So that's the only thing I see, is that it's a It's a 5.5% is what should be. And it's not the adding on a 10% to the existing 5% as the appellees indicated.
Okay. So, in summary, are you intending to vote for or against the motion to find that the planning board did not commit a procedural error?
I'm going to vote in favor of it, but I'm also want to point out that this could have been addressed a little bit different rather than addressing it from the standpoint of a plat note. During the hearing, if they had just talked about and acted upon whether or not they were going to adopt the 5 or the appellants and the staff analysis, or whether they were going to adopt the S4 and the appellees analysis. That could clear the whole thing up.
Okay.
So I'm just saying it's inartfully brought under the guise of a plat note when they could have solved it without going through that.
Okay. Nonetheless, in summary, you will vote in favor of the motion?
Yes.
Is that correct? Okay. That leaves me, I intend to vote in favor of the motion as well. And here's my reasoning. The appellants want a plat note to resolve what they classify as a dispute. I do not see this as a dispute at all, I must tell you. The provisions of the code are quite clear, to my way of thinking, what the maximum lot coverage is. And that issue will raise its head essentially at the time when somebody makes an application for a building permit, because as part of the determination whether or not to issue a building permit, the lot coverage of the footprint is of course being considered. And to me, that does not require a plat note to say whether it is whether it's 15% or 5.5. It is whatever the code requires at the time that the building permit is applied for. And the lot coverage can change. In other words, right now it is so many percent, but if for some reason the department and the assembly and everybody else agrees, the lot coverage can be changed. So it should not be cast in stone. And by way of a plat note, plat notes are restrictive covenants, and they govern the property and a certain aspect of the property from now until doomsday. And that is not the case here when we talk about lot coverage. So I believe that a plat note is inappropriate and that the planning board was correct in not requiring a plat note regarding the lot coverage provision. It's therefore that I intend to vote in favor of the motion. Any further discussion regarding this issue? Mr. Diaz.
Just one comment. We are at this board, we are not looking at the actual resolution of what the lot coverage is. We're looking at what the actual definitions for lot coverage are under the legal definition of Title 21. I think it's correctly stated. And reading the Title 21 references, 2107 B5 being one for conservation subdivisions, plus the table which I referenced earlier, and I'm not going to look it up again. That's sufficient basis for making this determination at the appropriate level, and I think that's the key at this particular instance. And I think the planning board acted appropriately and did not make a procedural error.
Okay. Mr. Stewart, any further comment before we vote?
No, but that is a good comment, that the plat is in there for the length of that plot existing, or that plat existing. And it could change.
Yeah. Okay, I have no further comments. Madam Clerk, and I see that the city clerk has taken over. Welcome, Barbara.
Thank you very much. We've changed clerks.
Yes.
Um,
So, but I take it you can read your predecessor's notes?
Oh,
And
absolutely.
that she made that she wrote the motion down? Okay. We are ready to vote. If you would call the roll on the vote, please.
Darren Guchow,
Yes?
Robert Stewart,
Yes.
Tomas Dia,
Yes.
And the motion passes by a vote of 3-0. And that means the planning board's decision not to require a plat note has been affirmed. Okay, zipping right along, we then come to issue number 3. And issue number 3 concerns the 100-foot screening along lot lines of lots 13 and 14 of the proposed subdivision. And again, I would like to have a positive motion regarding this matter, and it would go along the following lines. AMC 2108-070B4H does not require 100-foot wide common open space with level 4 screening along the western lot lines of lots 13 or 14 and/or 14 of the proposed conservation subdivision. And hearing none, I will make this motion myself.
You said does not.
So the
right?
question is,
Yes,
which one of you two gentlemen is going to second this motion at this point?
I'll second it for
Thank you,
discussion
Mr.
purposes.
Stewart. Let me just jot this down. All right. So here we go. I tend to vote in favor of the motion, and that means no screening, no additional 100-foot open space required. The planning department interpreted common open space as being tract A, and therefore it determined that tract A is greater than 150% of the 2 lots in the northwest corner, and thus no screening is required. That was the planning department's determination, and that's basically what I believe the decision came to. You need to read the definition of common open space with level 4 screening together. And the definition of common open space you will find in 2114-040, and that's on page 14-29 of our heavy book. 14-29. And when you look at that, it's the definitional section. It says, open space, comma, common. Open space for the common use and enjoyment of the owners and occupants of the subdivision, building, planned unit development, or condominium, period. Common means shared by all tenants and is distinguished from space designated for private use. So when we look at this, we find that there is in fact plenty of open space designated, and that is tract A of the proposed subdivision. The appellant says the proper interpretation is common open space with screening is required on lot 13 and 14 because 2 lots in the northwest corner abut the subdivision, and they are more than 15% greater than lots 13 and 14. Well, I don't think that's the proper way of looking at it. You need to read common space with level 4 screening together. Common open space is tract A. The common open space referred to is the common space that has been proposed in this subdivision. So the question is, which lots abut the common space? And when you look at the plat, and Oh boy, we have the plat here somewhere. I'm trying to find it.
Well, I think one drawing up if that helps at page 261, although
There's-
it's not the flat, but it's a drawing of it.
Wait a minute, where's my thick book here? Okay, here. It is on, what was the page number, Mr. Dieck?
I have one, on 261, there is a drawing of the.
That's what it is, okay. $259. No, that's not
okay.
what I was referring to.
Look at the one at 237.
Yeah,
237. I have too many references here.
Yeah, that's good. Like the
Right
flat.
there, right there. So when you look at the common open space, tract A, the only one that it abuts is one of the two lots in the upper northwest corner. It has nothing to do with lots 13 and 14. And because tract A is as required by, or is as addressed by the ordinance, is more than, tract A is more than, is it more or less than 150% of the coverage of the abutting residential lots? And to my way of thinking, the abutting residential lots are the two in the northwest corner. They are lots 12 and 13, and they are all less than 150% larger. Is that what it is? Yes. And so if we were to listen to the appellant here, it would require 100-foot space on lots 13 and 14 with screening, and frankly, that destroys those two lots altogether. And I cannot believe that that was the intention of the screening provision that the section referred to. So for that reason, I believe that the proper reference is simply to tract A, and that we simply need to look at whether tract A is more or less than 150% of the average of abutting residential lots. And if it is more, then there is no screening. If it is less, then screening is required. And in looking at the adjacent lots, I find that tract A in every case is more than 150% of the, in size, of the adjacent lots. So for that reason, no screening is required, and particularly no screening in lots 13 and 14. So I intend to vote for the motion. Mr. Stewart.
Okay. I was just looking at the language.
Of what?
At 2108-070B4H.
Okay.
Common open space with level 4 screening landscape to be provided along any lot line abutting a residential neighborhood where adjoining lot is greater than
Yeah, it's 150%.
of the average lot size along that lot line of the conservation. This abutting open space should be 100.
And what you read was small 4H, correct?
Right.
Okay.
Yep.
On page 8-33, it says on the bottom.
Yeah.
Okay.
Okay, I guess that would apply even though a tract is different from a lot. Hmm. Well, this was not what I was thinking about, but it certainly makes sense.
Okay. If you want to think about this more,
Yeah,
I'm not trying to press you here.
Yeah, this
right now.
This throws a kink in my thinking on this one.
It does, huh? Okay.
Yeah.
Mr. Diak.
Yes. Well, this is one of those interesting cases where we are at Board of Adjustment, where we look at the code narrowly based on record.
Yes.
We are not interpreting the code to design a subdivision. If I read the code as it is, in my view, intended to create its conditions, this whole section, which is 210807B, deals with a type of subdivision which may end up creating smaller lots than the surrounding underlying zoning district. In this case, it's R8. That in itself brings up the issue of compatibility between lots. Hence, I believe the intent of this section B4H is to protect the larger lots from more intense development along the site. And in my reading, actually, I find that the letter of the law is making this particular requirement applicable for those lots 14 and 13, and does not make it applicable for lot 12. And the reason for that is simply their size. Well, whether I think this is unfortunate, disadvantageous, or any of those adjectives, it is still how the code is written in my view. So in this case, because lot 13 and 14 are less than 100, or the adjacent lots to lot 13 and 14 are more than 150% larger than those two lots, strict application of the code would require that this is either going to go into a variance, or the lots reach the size where they don't require this particular condition. And if you ask me whether that's a good idea, I would clearly state it's probably not a good idea. I mean, you're right. It's 100 foot wide easement on or screening landscaping on a lot which is probably not even a whole lot bigger than that. But as far as interpreting what the code says, I think that's what the code says. So in the motion which is at the table currently, which says that that it does not require it, I would be on the contrary, and I would say I think it does require it, and I would not support it for those reasons. Now, where does that leave us? I'm not sure yet, but that's why we're discussing this.
Okay. You're looking at me. Do you have a question?
No.
No?
Nope.
Okay.
So-
Let me just see if I understand you. You're saying that screening is required on the westerly lot line of lots 13 and 14.
Reading the code, that's what it leads me to believe, yes.
100 plus a 100-foot open space.
No.
Well, wait a
Well,
minute.
it
That's
would
together.
actually, it would be a common open space with level floor screening, correct. It would require it, yes.
Okay, so where would the common open space be? On lots?
Apparently, along any lot line, which is in this case the lot, I think it's 8, the adjacent two lots to the northwest corner.
It's the two lots 1 and 2 of the Ferguson Jones
Lot
subdivision.
1 and 2, I guess. Yes. So those two lots would be the east property boundary of those two lots would be the subject property boundary. And again, I'm not making a value judgment whether it's good or bad. I'm making a reading of the code, and that's what that reads to me. And that's inherent in this subdivision because the design of the subdivision creates lots which are smaller than those two lots. This inherent conflict can be resolved by having larger lots or do a lot of things, but our job at this particular board is not to interpret the plat. Our job is to see whether this was a factual error.
So the screening would be on lots 13 and 14, is that what you're saying? That is your interpretation?
Yes, that's my interpretation. And again, uncanny as it may be, Lot 12, because of its size, comparable to those two other, probably would be exempt just because of its size. So as far as subdivision design, that's not very good practice, but as far as what the code says, that's what it says. That's my reading of it.
Okay. Mr. Stewart?
I need to ask you a question. Your interpretation of the common open space is to protect the conservation subdivision or
Yes.
protect the adjoining lots?
It's to protect the subdivision, not the... No, it would be to protect the adjacent lots.
Right.
But the adjacent lots here
It appears to me like the way your interpretation of the open space is that you were looking at protecting the lots in the conservation
Correct.
district or subdivision. But I think what this is trying to do is to protect those lots that already exist
the two rectangular lots you're
that
talking about.
adjoin the conservation subdivision.
Okay. Nonetheless, the level 4 screening should be on lots 13 and 14.
Yes.
It couldn't be anywhere else.
Right.
And
Well-
there would have to be 100-foot kind of a setback. I'm not sure that setback is the proper term. They call it 100-foot open space. Simply open space. 100 feet. That would be 100 feet on lots 13 and 14.
Yes.
Mm-hmm.
Well, that would destroy those lots. Because once you have 100 feet lopped off for open space, there's not enough space left to put a structure on it.
I certainly don't know if there is not enough space, but it certainly makes those lots much less reasonable
Desirable.
to plat this way than not. And hence my comment that if you are doing platting, this is where your variances kick in. Is that reasonable to have that requirement to apply? And if it is not, is it meeting the conditions of a variance to not adhere to the code? But there's no other remedy for the code except asking for a variance for this particular issue. And that was not part of this case. The
No.
appellant was just saying that this should have been applied, and your motion says that it should not be.
Correct.
And my interpretation is that yes, it should have been.
Okay. All right, Mr. Stewart.
If you do take 100 feet off those two lots, the whole thing would have to be redone.
Yes.
But I thought that this provision in here was to protect existing lots that would be adjacent to the conservation subdivision.
Yes. So, and the adjacent lots are those two rectangular lots,
Right, lot 1 and 2 of that
whatever it's called.
Ferguson-Jones subdivision.
Okay, and clearly you cannot require level 4 screening there. So it would have to be on the adjacent lots,
It would have to be taken out of
13 and 14.
13 and 14. Now, when you're talking,
Or do we talk about common open space with level 4 screening? Should you read that together? And at that point, then, the screening should be on tract A.
is Tract A considered a lot?
Yes. Absolutely, it is a lot. It is called Tract A.
Yeah, but in defining a lot, if you look at how they define a lot, it's bounded by streets and other lots that is described and fixed on the most recent plat of record. A tract, on the other hand, is a parcel of land reserved for future development, future subdivision or protection of open space and specific natural.
Yeah, that definition fits better because it is an open space.
Yeah, and if you look at the application, I mean, I was trying to figure out, is a tract a lot?
Okay.
On the application, there's room for a tract to be added, and there's room for lots.
Yes.
On the application, there's 16 lots. A tract is not considered a lot on the application.
Okay.
So I think you could also look at it and say, Tract A is not considered a lot, therefore it would not meet that definition that's used in B4H. I guess this further complicates the issue a bit.
It do. Common open space shall be provided along any lot line in a residential neighborhood. where any adjoining lot- Mr. Dieg, help us out.
I don't know if I can help you out, but I can tell you how I read the code and how I believe its intent is in this conservation subdivision.
Okay?
So the conservation subdivision is a planning to allow preservation of natural features or other significant features and basically combine them under a tract or in a tract, and that act in itself allows then, or the code allows for lots being smaller than the underlying zoning district. In
Yes.
this case, I think it's R8, so I think it's 4 acres.
It is, yes.
And this plat very diligently follows the rules in that regard. It has the numbers for the tract, subtracts it from the overall area. I think actually we're going to talk about it later.
Yeah.
And then assigns covered lot areas to have that math correct.
Okay?
So with that, the code wants to have some safeguards to existing properties. And in this particular instance, that safeguard is only required to protect 2 lots, which are on the northeast corner of this larger landmass, northwest, I'm sorry.
Mm-hmm.
And they are adjacent to lots 12, 13, and 14 of this preliminary plat. And the condition which is given under B4H states that any lot in the new subdivision, if it's reaching a threshold of being small, will trigger some sort of safeguards to protect the properties which are already in existence. Now, the rules apparently are that that threshold is 150% of lot area. So if any lot which is in existence is more than 1.5 times the size of the lots which are now being created, then that's a trigger for B4H. And the trigger is then to provide protection, and in this case the protection is a
Screening.
common open space level 4 screening. And the appellant brings the appeal saying that this particular code reference requires this common open space with level 4 screening along those 2 lots. And your motion states that it does not. But based on this analysis, I do believe that it does. And that's inherent in the plat. It's not by anybody else's doing. It's basically because of the plat has lot sizes which are adjacent to existing lots. and it is a condition in the code. So you can resolve that by either asking for variances and resolve it by that, or reconfigure the lots to be larger than what they are so they don't hit the threshold, but something has to give. And the question we have to answer, whether this is a real consideration in terms of being applicable, and my reading of it is that yes, it is applicable.
Okay,
I don't know if that's helpful, but that's how I read it.
that's how you read it. Okay. Mr. Stewart.
Do you think this could actually be handled with a variance? Because I don't know that the drafters intended the results that we're looking at in this particular situation. I don't think they thought of it.
In what regard you say that they didn't think of it?
Because both of these lots, what is it?
13 and 14.
13 is 1.66 and lot 14 is 2.16. So if you take 100 feet away and screening to protect these other two, that's going to be a significant reduction.
Yeah, but isn't that the intent of the code, that you don't do this kind of plats, which then don't meet the intent of the code? Again, the remedy in the land use code is variances to
Yeah.
get that particular section to not apply to those two lots. There is no other remedy in code to do away with it. You have two remedies: do something which meets the code letter and intent, or ask for a variance to get that section not be applicable. And our job here, and this is maybe my past planning board exercise, this was much easier at the planning board because you would come up with some sort of solution to this conundrum. Our only solution here is to say either it's applicable or it's not. And I'm reading it, I read it as applicable.
Okay. You're all looking at me, I know. Anything you wish to add, Mr. Stewart, and see which way you are leaning at this point?
Well, I think because this is protecting those two lots in the Ferguson-Jones subdivision, I'm leaning in voting against it.
Okay.
But I also question whether or not, oh, wait a minute, I guess it wouldn't make any difference. Even if the tract A is not considered a lot, I think 12 is, 3.99 acres, I believe?
Yes.
And
something like that.
150,
They are more than 150% of lots 13 and 14.
Right.
I think that much is clear.
yeah,
Yeah.
that one is.
Yeah.
That one is. Because the average, I think, of of all three of them would be around would be
So,
150% of those three average would be 3.9, so it's less than lot 12.
yeah, I don't think we're talking about
No,
lot 12
okay.
here at all. I think we're only talking about lots 13 and 14.
Yeah.
Mr. Diek, can you articulate why this requirement would exist? 100-foot open space and the level 4 screening?
I can't articulate why it exists. I can only interpret how it's accepted
Okay.
as municipal land use code. I can maybe allude to some fairly well-established planning conditions which would protect higher density properties from lower density this is not properties, higher density developments from lower density developments. That's a known planning fact. And there are all kinds of land use tools to exercise that. This particular tool does what we just read and applies as we just read. And I think the intent is exactly that, to protect higher intensity developments being detrimental to the lower intensity developments. And then we're not going to get into its quality as far as code, but that's the code. I think it's a clear intent, and I think it's a reasonable intent.
Okay. I'm looking at my notes. No, the other consideration, of course, is if a common open space were to be created on lots 13 and 14, common open space means it is for access and to be used by all of the owners in the subdivision, meaning in
Yes.
the conservation subdivision. But there's no access. So if you were to create a 100-foot open space, common open space, at the western border of lots 13 and 14, there's no easement, there's no way for the owners of the subdivision to get there, is there?
Well, not in the preliminary plat, but the easement is not there either. So,
But that's basically what you are saying the code demands.
yes.
The 100-foot, call it easement. It's called an open space, but
Yeah. Mhm.
it's basically a type of an easement.
Yes, I believe
Okay.
that's what the code requires. Yes.
Does that make sense? I'm looking particularly at lot, which is the one that is further to the south of 13 and 14. It's lot 13. You know, you can argue that there would be access to the easement, to the open space on lot 13 via the road, whatever
Yeah.
that's called there. But lot 13, there wouldn't be any access. So are you then also demanding that there be an easement created from tract A or somehow for the other property owners to get there?
The good thing is that I'm not demanding any. I'm reading what the code says, but let's speculate for a second.
Yes.
Step out of our shoes for a moment. There are very simple design remedies to solve this problem. It's not our purview to solve them. So in my view, just a few, I don't know if this is appropriate.
Oh,
but
absolutely.
Let's just be
Let's
a
hear it.
designer for a second.
Yeah.
One way to not have the problem, if you consider this as a problem, is allow compatible size lots along the adjacent parcels, which means that you get every lot which is along the perimeter to be not more than 150%, or not. The adjacent property wouldn't be 150% more in lot area
Yeah.
than what you create. And you can do that very simply by combining lot 13 and 14. This issue goes away instantly. Is that in the benefit of the developer?
No.
No. It's clearly no. Is it my job to speculate it at this board? Absolutely not. There is other ways to do this. You can create an access to that easement through one of these lots and grant it with that shape which then allow you to get there, which is part of planning process. Is that a benefit to the developer? Absolutely not. And is that my job to figure it out? It's certainly not.
No.
But there is a whole list of
Okay.
design considerations which I think we could go through, but this is in the preliminary plat stage, and the appellant is asking us to look at a fairly narrow determination, and I think what may happen, if I may just, go into some predictions, they got to look at their preliminary plat and make sure which direction which they want to take. One, again, could be variances. The other could be a reconfiguration of the
Yep.
preliminary plat, and it's under it's a perfectly reasonable thing to do while you are going from preliminary plat to final plat, because that's why the whole process exists. So, so in that regard, I don't think this is an end of the road kind of situation. We're just in a funky position where I think there's an applicable condition. I think it is not applied, and I think the appellant appeals for it because it's not in the record, and I don't think they are wrong.
Okay. I must tell you, that's a very persuasive argument. Mr. Stewart. In other words, let me just follow up on this. I'm sorry, Mr. Stewart. So what you're saying really is that what this section requires, H, is that there be a level 4 screening and the 100-foot strip on lots 13 and 14 for the protection of the 2 lots in the northwest corner. That's really what you're saying.
Correct. And I also say, as crazy as it may sound.
And really, Tract A doesn't really have anything to do with this
I don't
No.
believe it does. No.
I don't think
because
it does.
it doesn't touch either lot.
No. And also, it's not a lot.
Yeah.
It's a tract.
Okay. Mr. Stewart, I must tell you for the record, you have persuaded me and I will vote against the motion. Mr. Stewart.
Well, I had my real problem trying to get my hands around what you were saying about that common open space in the beginning, but I'm going to vote against the motion.
And it is for what reason?
Because I think we need to look at the exact wording of B4H,
Okay.
and it talks about the average lot size along that lot line of the conservation subdivision. So if you look at that and you look at the intent is to protect those 2 lots that are adjoining in what they call, it's the northwest 1/4 of the 1/2. I think
There should be some description somewhere, but I think we are all talking
There is.
about the same property.
Yep.
So
It's
I
the
think
same.
that's fine.
It's in the application, excepting therefrom the northwest 1/4 of the northwest 1/4 of the southeast 1/4 of section 25, township 12, etc. So they went from a basically, okay, they went basically down to about 10 acres for those 2 exempted areas, which is the Vargas and Jones. And to protect that, I think we have to follow exactly what 2108-070B4H says.
Okay. All right. I think it's fairly clear where we are. Are there any additional comments, Mr. Dieck?
No.
Mr. Stewart?
No.
I have no additional comments, and I have been persuaded by the 2 of you. So I think we are ready to vote. Madam Clerk?
Baron Kuchel,
Nope.
Robert Stewart,
No.
Tomas Dieck,
No.
All right. Having thereby specified our interpretation that 100-foot screening landscaping an open space of 100 feet with level 4 screening is required on lots 13 and 14. The question is, and we need to talk to our esteemed counsel here, is where do we go from there? We have basically passed a motion, and I'm running through all these papers here, and you need to forgive me here for a second. We have basically defeated a motion that says that B4H does not require a 100-foot wide common open space with level 4 screening along the western lot lines of lots 13 and or 14. So the question is, where do we go from here? Do we simply, and Ms. Kitchen, what is your suggestion here?
I think that what I would suggest is if you want to add that common open space level 4 screening to those two lots, that you modify the planning board's decision to, and you can put as a condition of their final plat approval that your interpretation of that ordinance is applicable to those lots and that they meet that requirement, that code requirement.
What does that do? And we need to ask Mr. Dieck, because he is the man with the practical experience on the planning board. If we say that is a condition of the preliminary plat, what does that do to the process?
If it's a condition of the preliminary plat, that basically goes into the implementation phase, and with all other conditions will get executed to the satisfaction of the reviewers. So I'm thinking that if it is a condition, the developers have an option to meet it in any way they choose to meet it, and that could be again a whole list of things.
You were talking previously, and I'm not trying to interrupt, but I'm trying to follow the thought process. You were previously saying that at that point the applicant can, for example, combine two lots into one.
That's one.
Okay, is that still possible, or do we?
Absolutely. As far as preliminary plats are considered, the municipality or the planning board decision approves a preliminary plat, and there is some jurisdiction given to the developers to make corrections to meet conditions which are part of the record. And every so often I have seen plats where eliminating or adding a lot was a common practice because it's not substantially changing the plat as it was presented. And because the condition is the one which requires it, it's part of the record. I don't think that would be necessarily a procedural problem. But again, I'm not the
No. We are not here to tell. We are not here to tell the developer what to do.
Right.
No, that I fully understand that. Okay, so do we then rule as a matter of law that a third or that an additional condition to approval of the preliminary plat is the screening? Well, how do we do this technically here?
As a matter
Help
of
me
law,
out.
you interpret the statute. So it sounds like you have interpreted the statute to require level 4 common open space level 4 screening on lots 13 and 14. That is the legal issue that you've
Yes.
decided. And then factually you decided that you interpreted the statute as a legal issue, and then you factually decided that it's required and it's applicable in this instance. And then your decision then is you can, based on those two findings, the legal finding and the factual finding, you could reverse the decision of approving the preliminary plat, or you can modify the decision, or you could remand.
Okay, so but in terms of procedure, the next thing we should do is we should address a motion that says 100-foot open space with level 4 screening is required between lots 13 and 14.
Yes.
I think you could even state it more broadly, but yes.
How would you state it more broadly?
Just state the code reference which requests the same thing, and you would say that was not applied, and apply that code reference, which is the 210807B4H, and
Applies to lots 13 and 14
14
of
and
the...
14 of the subdivision as approved in permanent plat, and rule that out.
And simply leave it at that. Does that make sense? In terms of procedure, I'm thinking, you know,
I think you still need to make
We
a
need to do
decision about
something
the
else.
plating boards that, well, you did, it would
We do.
decide. It would be reversing the plating board at that point.
Well, the point I think we have to make that I think it's a very very high threshold, at least to me sitting here, to deny the preliminary plat because of this issue. I think that's heavy-handed. I think there is better ways to deal with this issue, and the better ways to deal with it is addressing or finding that particular code section applies, and then state that the resolution of that condition or that finding
Is
is left to the developer and the municipality, which
can we do that?
I think that technically that would be seen as a modification of the plating board's decision, where you are requiring, the plating board said that they weren't required to adhere to this ordinance, and you're saying that they are.
Actually, that's a question I have, because the planning board didn't say anything, basically.
No, that's true. It's not addressed anywhere.
So therefore, the appellant calls attention to this matter in the appeal. It's not part of the record as a dialogue, and the planning board not acting on it. I think that's two different conditions. They simply misapply the code by not applying the code. I think that's a remedy which we can.
Should we leave it at that? And simply state, would you think about that, please?
Mhm.
Because, you know, we can address the application of B4H or whatever it's called, and simply state by way of motion that section applies.
I believe that would be
That's
definitely calling
yes.
attention to this
But
issue.
then, what is the consequence of that? What is the consequence of that? Do we tell the board to address that issue?
Based
how
on-
do we handle that?
I think the cleanest way, and maybe this is something where you can step in, Mr. Dank, where I think that placing a condition, say, the condition would be that the final plat must adhere to this code provision. The plating board's decision has conditions
Well,
already put onto it, and the Board of Adjustment can modify that decision, and you can modify it by adding a condition, and the condition could be
that they need to adhere to
they
the
need
section.
to adhere to the
Yeah,
statute.
that's where I was heading, listening to your original statement, because I think we only have three choices. Well, maybe more, but I can think of three. One, you just
For-
simply remand the plat. I think
Yes.
it's heavy-handed.
Yes.
Two, you tell the planning board to address it by remanding this issue, but there's nothing to remand because they never heard it.
Yeah.
And then three is putting it into the record, modifying the actual conditions of approval by adding this issue to be resolved. And that generally allows a leeway to the process to take place and the solutions to come up in the actual going forward.
Okay,
when they
so
go forward.
we would add a condition of approval to what the plating board found as conditions, and there's a whole bunch of conditions.
Correct.
We know that. And the condition would say, you must deal with
Actually, it would
4H.
be resolve the.
You need to resolve 4H.
Yes, correct, basically. On lot 13 and 14.
Okay. So it would be a two-step process. We first say that 4H applies, and then number two, we modify the conditions of approval by directing the applicant to resolve the requirements of 4H in light of our decision. Does that make sense?
I think it does, yes.
Mrs. Stewart? You're a lawyer.
Yeah, it does.
I'm sorry. That, you see, a two-step process. We first say that 4-H applies.
Yeah.
Okay?
Turn the
and then
motion around
screening is
and make it
required.
positive.
Number one. And number two, we modify the decision of the preliminary approval done by the planning board by requiring adherence to a 4-H.
With an additional condition.
Yeah, we simply
Yeah.
add a condition to the conditions of approval, you know, the whole long list that
Yep.
they have, requiring resolution of the application of 4-H.
I think that
Does that make sense?
Mm-hmm.
All right.
I think
How
it'll
do you
work.
feel about that?
No, I think it'll work. Do we need to add in accordance with our decision?
Of course.
Okay.
Because remember, the first thing we do is we say 4-H applies.
Applies.
Okay, and then we say, in the light of our decision that 4-H applies, an additional condition of approval shall be. That requires, is that a modification? What's the proper term that we are doing? We are modifying.
Modifying the planning board's decision.
Okay. By requiring an additional, or by adding a conditional, by adding an additional condition of approval
The final.
of, no,
Preliminary.
Preliminary.
Do you want me to read what I've been writing and editing while you've been talking?
yes.
That might help.
Please.
Would you like me to read your motion?
Well, it's a two-step motion,
It
first
is.
of all.
So here's what I have. A motion that AMC 21.08070B4H does apply to lots 13 and 14 as approved in the preliminary plat?
Yes.
Is that correct? Okay.
That's the first motion.
Semicolon or period. In accordance with the board's decision, an additional condition of approval
Is added.
of the preliminary plat is to modify the planning board's decision to address 4-H. I think there's something missing at the end, but at one time you said all you wanted to direct them to do was address 4-H.
Yes. Does that make sense?
To require it to address 4-H.
Can we say comply with?
In light of the decision that 4-H applies. We need to circle back to our decision in some fashion. Why don't we do it in a two-step manner? The first one is a motion that B4H of 2108, whatever the section is.
07. The 210807.
070B4H applies. Okay, all right, that's a motion. Mr. Dieck, are you going to make that motion?
I would love to make that motion.
All right.
So,
And Mr. Stewart, you will second that?
I'll second it.
All right. Any discussion regarding your motion?
I think we have plenty of backing for this one, so, no.
No additional comments. Mr. Stewart,
I'm ready to vote on it.
you're ready to vote on it. Madam Clerk, would you, just to be on the safe side, read the motion once more?
The motion is that AMC 21.08.070B4H applies.
Applies to,
To the, applies, do you want me to put the?
yes, applies to
lots
section,
13
to lots 13 and 14.
As approved in the preliminary plan?
Yes.
Yes, that's good. Gotcha.
Do we all understand the motion? Are we ready to vote?
Yep.
Madam Clerk?
Darren Rucho,
Yes.
Robert Stewart,
Yes.
Thomas Diaz.
Yes.
All right, so that motion passes, and now we need to give some direction in some, well, we need to follow up on this, now that we have said that it applies. And now we need to talk about modifying the planning board decision by adding an additional condition of approval. And that is, the condition of approval is adherence, no, consideration.
No, to address, I think you want to address it.
Is,
Actually,
can we simply say it that way? You have the experience, Mr. Dieck. You know, you've been on the planning board. We have not. If we simply say we are modifying the planning board decision by adding an additional consideration of approval
to resolve
to resolve the application. No, not resolve the application, to resolve the requirement to adhere. Requirement
I have a suggestion.
to adhere to the provisions of that section.
Yes, sir. Yes, I think that's good.
Adhere. And
In accordance with BOA ruling.
in board's ruling. Madam Clerk, did you get this?
Yes,
I'm-
Mr. Chair.
Okay, could you read it?
Yes, Mr. Chair. It's a motion to modify the planning board decision to add an additional consideration of approval is to adhere to the provisions of section 4H in accordance with the Board of Adjustments decision.
Mr. Chair?
Yeah.
These
Mr.
are
Dieck.
conditions of approval, not considerations of approval.
Conditions of approval. An addition is an
To
additional
add a condition, to add as condition of approval, as condition of approval, to resolve the requirement to adhere to the provisions in accordance with this board's decision.
So I'm going to need a little bit of help again with.
Wordsmithing.
I have additional, so help me with that. To modify the planning board's
Decision. To add
To add,
as condition of approval.
okay? Then I have to modify the planning board's decision to add as condition of approval to adhere to the provisions of section 4H in accordance with the Board of Adjustments decision.
Ruling or decision. Yes. Does that make sense? Do we all understand the motion?
Yeah.
Yes.
All right. Madam Clerk, would you call the roll?
Darren Kuchel,
Yes.
Robert Stewart,
Yes.
Thomas Diaz.
Yes.
And the motion passes 3-0. All right. We have now been at this for a little over 2 hours, and I think it is time to take a break. And I see that Mr. Dieck is already
I can
grabbing
hear
the
you.
water bottle. So, why don't we take a 10-minute break at this point?
Yes.
We are back on the record in case 2018-1. Moving right ahead, the next issue concerns the Planning Board's implicit factual finding that Big Country's application accurately reflected the conservation subdivision's total acreage. And the issue is whether that decision, that implicit decision by the Planning Board, is supported by substantial evidence. So, as I prefer to have positive motions, I will entertain a motion that substantial evidence supports the Planning Board's implicit finding of the applicant's statement as contained in the application of the total acreage of the proposed subdivision.
So moved.
Been
Second.
moved and seconded. And Mr. Stewart, would you address your motion, please?
I think the information that's in the record itself, there's a lot of different information in there, but what it boils down to is what is actually considered the gross amount, gross acreage, which is, it's set up as 80 acres. And you can see that from the legal description. And when you subtract the rights of way for roads, other areas that are not being developed, and especially that northeast corner where the Canyon Road and Dearman intersect, that is not being developed. So if you look at the worksheet itself, that's on the record at 250. It's dated 11/9/2017. That lists the net acreage as 65.63 acres, with 16 lots totaling 42 in a tract A of about 22.97. In the application, it clearly states that the north half of the southeast quarter of Section 25, Township 12, North Range 3 West, Seward Meridian, located in Anchorage Recording District, defines it, and it also exempts the two lots that we had talked about earlier, and that is the two lots are in that northwest quarter of the southeast quarter of Section 25. When you look at everything, you've got approximately 70 acres that remains, less the roads, less the existing rights of way, and that northeast corner. And I think that is, it's not unreasonable to estimate that the roads in that cul-de-sac are going to equal roughly about 4 acres. So I think the amount that's used there, which is 70 acres, that is totally on par with the Terrasset report, which is in the record at 411, and that refers to the gross amount of 80 acres, and that's what you get when you do a division. I don't see any substantial disagreement with the amount that they're talking about in here.
Okay.
I think it's the misunderstanding between what is a net and what is gross. And your gross is 80 acres, and your net is right around 65 to 70 acres. If it's 70, then you also have to account that you haven't subtracted the amount for roads and rights of way and everything. And Canyon Road is in fact, the right of way does abut into and is part of this 80 acres, even though it appears to be a road that is going to be worked on in the near future.
Okay. So, in summary, do you support or oppose the
I-
motion?
I support it because I don't see any substantial disagreement as to the amount of net versus the gross amounts.
Okay, Mr. Diaz.
Mr. Chair, the appellant's state excuse me, wrong page.
No problem. Take your time.
The appellants state or assert that there is a confusion on the acreage of this subdivision, and that is grounds for further investigation by the planning board. I do find this factually incorrect. The record clearly states the acreage both by the petitioner as well as staff. It is also supported by the map, simply stating that an 8-acre parcel being missing its northwest corner by 2 lots. I found no substantial evidence to substantiate this claim in the record, and I will support the motion.
Thank you. I too intend to support the motion, and here is my reasoning. The appellants state that the wrong acreage was stated in Big Country's application, and that different sizes were listed in various applications, and that the planning board as a result has a procedural duty to determine the actual size as setbacks and open spaces are required by it. Well, in my view, the planning board approved the application, thereby implicitly agreeing with the size stated by Big Country, and the only issue is whether that is supported by substantial evidence. Terrastat stated in its report that the subdivision is approximately 80 acres, of which 10 acres may not be included in the subdivision, and those 10 acres presumably are the 2 lots in the northwest corner. And thereby they come to 70 acres, basically, that the subdivision at issue contains. And that is in the transcript in the record on page 411. S4's worksheet in the transcript on page 250 refers to 65.63 acres, and that is the net of the subdivision itself minus roads, and therefore is the net amount, and that comports with what the applicant has stated. As a result, I do not see any significant error that the planning board has made, or that it has a duty to determine the actual size, because actually the appellant and 2 engineering firms hired to investigate various aspects of this proposed subdivision came all to the same conclusion. There is simply no evidence of any larger size that I can see, and it is for that reason that I will support the motion as well. Any further discussion?
If I could just make one
yes,
comment.
Mr. Stewart, take your time, please.
You said presumably they were not included. They are, in fact, accepted.
They're excluded, yeah.
Right.
Right.
In the application itself.
Yeah.
The 10 acres for those 2 lots.
Okay, all right. So, so Terrasat, when they said 80 acres, that included those 10 acres
Yes.
that have been kind of bitten out and been split off as separate lots. Yes. Anything else, Mrs. Stewart?
No.
And yes, it's Mr. Diek. Any further discussion?
No, I don't have
Seeing none, I have nothing further. Madam Clerk, are you clear on the motion?
Mr. Chair, could you please restate the motion as
Yes.
read to begin with?
Yes. The motion is as follows. Substantial evidence supports the planning board's implicit finding of the applicant's statement as contained in the application of the total acreage of the proposed subdivision.
Thank you, Mr. Chair.
All right, and if there's no further discussion, please call the roll.
Darren Cruchow,
Yes?
Robert Stewart,
Yes.
Thomas Diaz,
Yes.
Okay, and the plating board's decision is affirmed by a vote of 3-0. We then come to the next issue, and that concerns the contention by the appellant that plat map and notes should include riparian and stream setbacks. And that has been addressed by our esteemed lawyer in her confidential memorandum as point 11. And again, I'm going to ask for a positive motion that the plating board did not commit a procedural error by failing to require plat map and plat notes of the proposed subdivision to include riparian and stream setbacks. And since I do not hear any seconds or any person volunteering to make that motion, I will do it myself. And it will be as stated. Madam Clerk, do you want me to repeat it?
I would love it if you would repeat.
Oh, I will
Mr.
be
Chair.
happy to. I move that the plating board did not commit a procedural error by failing to require plat maps and plat notes of the proposed subdivision to include riparian and stream setbacks. May I have a second, please?
Yes.
Mr. Diak seconds the motion. I will simply address it. The plating board decision required plat notes mandating compliance with AMC 21070.020, and that addresses setbacks. That complies with 2103 208E. Does that make sense? Requiring plat note where there is a use restriction. In other words, what I'm looking for is the plat note requirements, and that is 2103
200C.
200C C8E. Thank you. A plat note is a restrictive covenant, basically. There is no affirmative duty to specify the amount of undevelopable land, which is what the appellants want us to hold by to delineate stream setbacks on plat maps. So I do not see that the plating board made an error, a procedural error, by not including the stream setback and riparian setbacks on either by either plat note or specifying a showing on the plat map. I therefore intend to vote for the motion. Mr. Diak.
Yes, Mr. Chair, just looking at the references, but basically I would agree with your analysis. I do believe that the motion or the planning board has not committed procedural error because the planning board did reference the applicable code requirements for the plat to adhere to, and there is no evidence or no requirement, and there's no evidence of the requirement that anything in the code exists which is explicitly stating that the plat has to actually show the setback requirements or show the stream setbacks. And the practice has been in many plats that they were or they were not. And in this case, the planning board took the position that they reference the code, but they do not require it. And I don't think they have made a procedural error of doing that.
And therefore, you intend to...
I will intend to support the motion.
Okay. I should add, before we ask Mr. Stewart for his comments, that there is a flat note mandating that the setback requirements of 21070/020 be adhered to.
Yes.
And it strikes me that that takes care of the issue. That is notice enough and decision enough that whatever the code requirements are at the time that a lot is planned to be developed, that section regarding setbacks be adhered to. And I think that is all that can be required of the planning board under the circumstances. And therefore, I find that there's no error. Mr. Stewart.
I agree with that, and I'm ready to vote on it.
Okay. Any further comment, Mr. Diak? Anything further?
The only comment I made that things change. In the past, as I mentioned, there were plenty of plats in the municipality of Anchorage which show stream setbacks. That does not mean, in this case, the issue is whether the procedural error was committed by the planning board by not requiring it. I think because the reference is therein as a plat note to adhere to the condition of the land use code, I think it's no procedural error.
Okay. Thank you, Mr. Diak. Thank you, Mr. Stewart. I have nothing further. Madam Clerk?
Baron Kuchar,
Yes?
Robert Stewart.
Yes.
Thomas Diak.
Yes.
And the motion passes by a vote of 3-0. We now come to issue number 6. And issue number 6 concerns the application's technical reports and analysis. And I would ask for a motion that the planning board did not commit a procedural error in requiring the applicant to provide additional technical reports and analysis before approving the preliminary plat. Mr. Stewart.
So moved.
Thank you. Mr. Diak, will you second that?
Yes, I will. Yes. One clarification though. Did you say that did not require for them to?
Yes.
Mm-hmm.
Yes.
Correct.
They did not commit a procedural error in not requiring the applicant.
Yes. Thank you. Second.
Thank you for making that clear. I appreciate it. Okay, Mr. Stewart.
Well, there's a lot of information in here. If you look at the index, you've got several engineering reports. You've got the review by the planning department. You've got several reports regarding water conditions and soils, and that's at record 246. Hang on just a second. So there's a list of, if you want to look at the reports themselves, you got the preliminary damage impact analysis. That's on record 268 to 287. Geotech soils report, North Rim Engineering. That's on record 288 to 306. The soil log and percolation test by Garnis Engineering. That's at record 308 to 317. Wetland determination by the Corps of Engineers. And that was done early on in 2015. That's at record 318 to 321. Preliminary determination of wetlands and waters. Another Hemlock Scientific did that one, and that's at record 322 to 407. And you got the groundwater evaluation by Terrasat, and that was done in 2017. That's at record 408 to 429. When you put all these together, it doesn't look like there's any deficiency involved, and it looks like the code has been complied with. And I plan on supporting this motion.
Thank you. Mr. Diak?
Mr. Chair, I think there is substantial evidence in the record that the required engineering studies and investigation to prepare this application were completed prior to the meeting, and you heard the detailed listing of those, and I have no additional statements to add. I would support the motion.
Thank you, Mr. Diak. I likewise intend to support the motion. The applicants would have us, they claim that the soils tests and water tests failed to include reports by Northrim and Terrasat. That may or may not be true. Apparently, I'm not going to state one way or the other. Assuming arguendo that those reports were not there, a series of other reports were provided, as had been recited by Mr. Stewart. In addition to that, the Planning Board's decision in paragraph 4D stated, the conditions of approval will require the subdivider to prove the MOA on-site water and water services division that AMC Title 15 regulations are met for each lot. The required information includes soil testing, percolation testing, and groundwater monitoring. So, in other words, even though information may be missing at this point, at this stage, as a condition to the approval of the final plat, soils test and water test and have to be provided in compliance with Title 15 of the Municipal Code. And consequently, even if those tests were missing at this stage, they will be required in the process of approving the final plat. So for that reason, I do not find that there was a procedural error that has been made by the Planning Board, and I will approve the motion because the conditions of approval require the applicant to demonstrate compliance with soils and water requirements of the municipality. Any further discussion?
Before we vote on this, can I have the motion read back to us, please?
Yes. Madam Clerk, would you read the motion once more, please?
Yes. Motion is that the Planning Board did not commit procedural error in not requiring the applicant to provide additional reports and technical review before approving the preliminary plat.
To include riparian and, oh, I'm sorry, yes, correct. Yes. Withdraw that comment. Read the wrong paragraph.
Yeah,
Yes.
we're referring to the technical reports. And
We are
the
referring to
analysis.
the technical
Okay.
reports, yes.
That works.
Yes. Okay, any further discussion in the light of my confusing comment? Nope. Madam Clerk?
Baron Gutschall,
Yes.
Robert Stewart,
Yes.
Thomas Diaz.
Yes.
And the motion passes by a vote of 3-2 to affirm the Planning Board's
3-0.
3-0, I'm sorry. 3-0, the Planning Board's decision. We now come to the last issue, issue number 7, and that concerns the minimum lot size exception. And I will entertain a motion that the preliminary plat approved by the Planning Board complies with the minimum lot size exception of AMC 2108 8.070B4. And Mr. Dieck seconds that motion. No, he makes the motion. I'm sorry. And Mr. Stewart presumably is
I'll second
seconding
it.
the motion. Okay. Let me just make some notes here. All right, and we are now ready to discuss the motion. Mr. Dieck.
Yes, this motion is related to whether the conditions of 210807B4 are properly applied. It doesn't state in either way whether the planning board applied them properly, so it's up to us to interpret it. So my interpretation is that this particular code requirement allows a concept in planning which would dedicate common open space, basically natural areas, in exchange of smaller lot sizes, with the condition which is under B, same 210807B6, where the actual open space requirements are stated. And looking at the subdivision, this is an R8 zoning district subdivision. Underlying zoning is R8, and minimum lot size of these parcels would be 4 acres. With the conservation subdivision, they were reduced. And the question here is whether it properly complies with the minimum lot size exception, meaning whether it transfers the reduction of lot areas into the common open space. And looking at the evidence in the record and doing the math, it appears that that's correct. The additional lot area, which was gained by the reduction of the lot sizes from 4 acres to less, is properly attributed to the tracts, which are conservation easement requirements, and they do meet the minimum open space requirements. And because of that, I think the motion is one which I can support.
Okay, thank you. Mr. Stewart.
Well, he's pretty much said everything that I was going to say. The main thing that I was looking at was whether or not the smaller lots, by reducing the size, whether it was used for common open space, and it's clear in the record that it has been. And it meets that the threshold that's set forth in subsection 6.
Minimum open space.
Minimum open space, right?
Okay. All right. And as a result, what is your position regarding the motion?
I'm going to motion. I'm going to vote for it.
Okay. I intend to vote for the motion as well. The argument by the appellant is that of the 16 lots, 15 are subpar, so to speak, and that's not the intent of the ordinance. But when we look at 210807B4, the introductory sentence of that says, conservation subdivisions may include one or more lots that do not conform to the minimum lot size or lot width dimensions of Chapter 2106. One or more lots. And we are asked to interpret the term one or more lots. Does that mean it is 5, it is 6, can it be all? And to my way of thinking, there is no limit in the number of lots that can be smaller. And that's what the term one or more means. Consequently, you can have all 16 lots that do not qualify to the proper size requirements in that zoning district. assuming that all the other conditions of the chapter apply and are complied with by the conservation subdivision. 2108-070B4 describes 8 conditions for lot area reduction. The number of lots is not one of them. If the assembly had intended a limitation on the number of lots that could be subpar in a conservation subdivision, it could have simply added a provision that would state that. But it did not. Furthermore, more, as stated in the first sentence of 2108-070B4, simply means more than one. It contains no limitation. The purpose of conservation subdivisions is to provide for compact living space with large open areas. If you were to limit the number of smaller lots, it would defeat the whole purpose of the subdivision, of the conservation subdivision. And it is for that reason that I find that the platting board, that the preliminary plat approved by the platting board complies with the minimum lot size exceptions contained in 2108-070B4. And I therefore intend to vote in favor of the motion. Any further discussion? No?
No.
Madam Clerk, would you call the roll?
Baron Kuchar,
Yes.
Robert Stewart,
Yes.
Thomas Stevens.
Yes.
And the motion passes by a vote of 3-0 to affirm the planning board. We are now at the end of the issues presented to us for review. And when we look at what we need to do next is we need to come to conclusions, and the conclusions are that the findings of fact are what they are, and in 2 instances concerning issue number 1 regarding the Canyon Road variance, and issue number 3. Issue number 1, 2, 3. That's the open space with level 4 screening. We did not agree with the decision of the planning board, and in the case of the former, we have decided to send the matter back to remand with direction to specifically state whether the 4 considerations contained in the variance section specifications have been met or not. And regarding the issue of the setback, we simply added an additional consideration, or condition I should state, to the approval of the preliminary plat. So those are the conclusions, and they will have to be put in good wordsmithing form. And presumably, and with regard to all other issues, the decisions of the planning board are affirmed. Okay? So we have really 3 decisions that we are concerned with here. I'm not sure that we can go any further tonight regarding this. We have a meeting scheduled. Yes, Mr. Diek.
Mr. Chair, I don't know if this is the appropriate time, but probably is, because if we end, it's not going to be appropriate. So I think at the first particular issue, which was the remand, we were specific on how the remand will take place, meaning that it's conditioned that way. I just want to make sure that it's on the record that we have actually sanctioned that the remand is to address the 4 conditions of approval for the variance, as well as allow additional information or additional new information to be gathered from the public and from the developers to do so.
Yes, thank you for specifying that. And that is indeed exactly what we approved, yes. Anything further, Mr. Stewart?
No.
Nothing from you? You are satisfied that you can put this in the final form so that we can consider this tomorrow?
Mm-hmm.
Okay. Madam Clerk, anything further that we need to discuss here? You have discussed the procedure, how to finalize this tomorrow, okay? And that's workable for you, and it's workable for you?
Mm-hmm.
And I will certainly be available to sign whenever, okay? All right, so having then ruled on the issues, what remains for us to do is to consider the final order, and some wordsmithing is obviously required for that. It being 8:30, I don't think any of us want to do that tonight, so we will prepare something tomorrow during the daytime, and we will meet again here at 5:30 tomorrow night, and hopefully it will not take 4 hours. So, if anything else to address regarding that issue, do you have anything further regarding that? Okay, all right. Anything that the two of you wish to add to this, Madam Clerk? Okay.
Oh, one other thing. I would like to thank council for going through and helping clarify the record. There was a lot of information in there that was not part of the record, and I thank you for sifting through that and finding the things
Yes.
that were not part of the original record.
Yes, okay. Any comments you wish to make at this point?
Ditto.
Okay, well, I simply want to state publicly that the board is very sorry that this process has taken so long. After all, the hearing before the planning board was in January of this year. We are now almost middle of November. To my way of thinking, that is an inordinate amount of time to consider an appeal. And frankly, I wish we could have done it on a much shorter timetable. It would have been to the benefit of the appellant and to the benefit of the applicant. But for various technical reasons, that was not possible in this case. So I'm very sorry for that. And it appears that there will be maybe another public hearing, so this process isn't over. Other than that, I want to thank the clerk. Thank you for being here tonight. I want to thank Ms. Kitchen. Thank you very much. You wrote a terrific memo. And I want to thank the other two board members for your patience with me when I misspeak periodically, which I did plenty of times tonight. And the next item on the agenda is audience participation. But I need to warn you that audience participation may not concern adjudicatory matters. So if you want to address the board at this point, it can have nothing to do with the case that we just considered. Okay? So is there anybody who wishes to say something? Yes, ma'am.
I'm the one who was the applicant in that brief and notice of appeal. And I would like to thank the board members for your really very heartfelt, sincere, and considered diligent review of everything. The people were very well prepared, and we all appreciate that. I have a general question. That does
As
not
long as it
concern-
does not concern the case.
This does not concern the case. I'm concerned about the fact that a board sitting in your position can, in any case, before you utilize a confidential memo that the public has not had access to. I would take issue with that, and I would request that the memo be made available at this point, since your decisions have been made.
I understand your concern, but that cannot be done. The condition under which the memorandum was prepared, in this case by Ms. Kitchens, was that it be given to us and her opinions be given to us on a confidential basis as we are her client. So it is the usual attorney-client privilege that applies in this case. And it is for that reason that that memorandum cannot be made public.
Does that happen with you folks?
All the time.
Routinely?
That is standard operating procedure.
And I can speak generally.
Yes, why don't you?
What the memo, it's nothing secretive in that it talks about, it summarizes both briefs, and it summarizes the applicable law, and it summarizes the facts. And that is pretty typical in any adjudicatory setting where you have a confidential bench memo.
You know, the same thing applies. Judges have law clerks, and law clerks are there to prepare the judge for a decision. And so they prepare memos that are not public record. It's essentially the same kind of a situation. Okay? And I do understand that you would like to see it, but for the reason stated, that cannot be done. Okay? Anything further? If not, I will simply, if there's nothing else to be considered, we are adjourned.